Hi, good afternoon or good morning. Good morning, everybody. Welcome from the Philippines. This is Chris Nelson. I'm chairman of the British Chamber of Commerce. It's 5 o'clock here, and I believe it is 9 a.m. in London, so greetings to everybody. Today, what we're going to be doing is focusing on the Visayas and also IPR, intellectual property rights in the Philippines. For that, we have two speakers. Let me first of all introduce the first speaker, which is Gustavo Cadena Jr. He is the Provincial Director of the Department of Trade and Industry, Iloilo Provincial Office. Engineer Cadena joined the government service in 1980, and obviously he's progressed through various stages. He holds a Master in Business Management from AIM, Asian Institute of Management here in the Philippines, and of course he is a licensed engineer. So he will be able to take us through in depth, and this links to our trade mission, which we are taking to Iloilo on the 8th and 9th of March. So we're very much looking forward to the presentation of Engineer Gustavo Cadena Jr. What will happen after his presentation, we will have a presentation by Edmundo Baranda, obviously to get you involved, and once again we will have a wrap-up session which actually
Apologies for this, everybody in the audience. There seems to be some technical difficulty on the Chamber's side. They might be struggling with their internet. So I would like to suggest that we move on to the presentation by our first speaker, who was already introduced. The floor is yours.
Okay, sir. Okay. Thank you very much, British Chamber of Commerce, the Philippines, for this opportunity to make the presentation on the investment opportunities in our region, Region 6 or Western Visayas in the Philippines. My warm greetings to everyone. Magandang araw sa inyong lahat. Let me start with a quick presentation of the region. We refer to it as Western Visayas or Region 6. It is located in the central part of the Philippines and one of the three regions in the Visayas Islands. It is mainly composed of 6 provinces, 4 in Panay Island, which are Iloilo, Antique, Capiz, and Aklan, and 1 province which is in the western part of Negros Island, which is Negros Occidental, and 1 province in Guimaras Island. The total land area of the region is 20,223 square kilometers, with a population of approximately 7.5 million people as of the year 2016. The gross domestic product of the region is 324 billion Philippine peso. $1 is 50 Philippine pesos. The growth rate is 6.1% per year. The highly urbanized cities of the region are Iloilo City in Iloilo Province and Bacolod City in Negros Occidental Province. There are 4 international airports in the region with direct flights to Hong Kong, Singapore, Korea, Japan, and Thailand, among others. The region's economy is mainly in agriculture, although recent developments in trade and commerce has made the region as one of the major growth centers in the Philippines. Consistent with the government's policy for promoting business and economic activities in the regions, such as Western Visayas, and because of congestion and lack of investment expansion area in metropolitan Manila, the potential for regional dispersal of industries has become very attractive and viable at present. Now, I will present the opportunities in Western Visayas for your investors and businessmen for them to seriously consider. There are 2 major areas and opportunities for investment based on what are the region's resources and what we need and require to further grow and prosper. The first area for investment is in agribusiness, especially on agro-processing industries. And first among this, in the cacao production and processing industry. At present, there's a total of 1,644 hectares of land planted to cacao, with a total of approximately 1 million trees. So the advantage for your investors to invest in this area is the raw material source advantage. Why? Because the Philippines, being in the tropics, we are among the few countries in the world which can grow cacao. Philippines, like Africa, while countries in Europe, including the UK, with your temperate climate, you don't have cacao. So investment opportunity in cacao would be an advantage for your businessmen in your country. And one thing good about what we have done on the industry is that we have started to work with local investors here who can be your local partners. We have organized the national as well as the regional council for cacao, where the roadmap for this sector was recently signed by the secretaries of the Department of Industry, Trade and Industry, and Department of Agriculture, witnessed by the Honorable President of the Philippines, President Rodrigo Duterte. So these are, so you see the cacao plant, and we have sample of the products made from cacao, which of course would be cacao beans, choco tablets, or we call it tablea, and cacao powder. But we could go further, especially with your partnership, with your investments here in the region. We can go into fine chocolate making, like what we have in Europe. So investment opportunities in cacao would be in cacao nursery and plantation, farm management and production technology, post-harvest and processing machineries and equipment, and of course, cocoa and chocolate processing plant and facilities. The next commodity or crop that we have potential for development in the region is coffee. Like cacao, for coffee, you would also have the raw material source advantage, because basically cacao and coffee can grow in the same areas in the region. The two major coffee varieties which are grown in the Philippines and in the region of Western Visayas are Arabica and Robusta. And of course, recently it's a worldwide trend that coffee shops and coffee has become the what you call the drink that people would want to take instead of alcoholic drinks when they have their rest and recreation. So investment areas in coffee would be similar to cacao. That would be in nursery and plantation, post-harvest and processing machinery and equipment, such as those required for drying, roasting, grinding, and as well as an integrated or a complete coffee processing shop or plant, as well as maybe machines and equipment, as well as accessories that would be needed by the operation or operating coffee shops. You see here beans and of course the ground coffee that comes out of the cacao beans. So as you see, the drying is still crude, and we need investments in these areas to upgrade the drying, the grinding, and the post-harvest facilities for coffee. The next crop for development and for further upgrading is on coconut-based products. In the region, there's a total of 167,449 hectares planted to coconuts, with a number of trees numbering to as many as 17 million rather, 104,902 trees. 50% or more than half are fruit-bearing. So investment opportunities in coconut-based products on farm and plantation technology, processing, machineries and equipment. For example, for oil production and pharmaceutical products, equipment and machineries, as well as for laboratory equipment. As we see the products that come from coconut. Coconut is referred to as the tree of life because there are so many products that can come out of from cocoa core, have wide application in even in electronics, in cocoa coir, in soil erosion prevention, coconut virgin oil, and of course even food products coming out from coconuts. The next group of products where we can also have potentials is in the area of processing fruits and nuts. And we have here several of these fruits and nuts. Next, of course, we have the mango. Mango in the region, in the Philippines, is very popular. So fresh mangoes, both for domestic and exports, would be still of high potential, as well as, of course, the need for investments in fruit treatment, in processing and post-harvest facilities, as well as in processing the fruit itself. No? They could be dehydrated, or they could be dehydrated and properly packed or packaged for the international or the global market. So we have here, we show the products that are now being processed or produced in the region, but we still see a lot of upgrading in terms of packaging, in terms of production technology for the global. Then we have pineapples are also widely grown in this part of the country and Visayas. of 840 hectares and a production of 16 metric tons per year. Still, the investment opportunities would be on farm management and technology, treatment for fruit selection, packing, and the complete processing plant. The other very widely grown fruit, or we call it what's called fruit or plant in the region is banana, and we have a total of 135,000 metric tons, or rather hectares planted to banana, with a production of 332,761 metric tons. So banana could be into banana chips and other what you call processed food. Then of course we have the local products that come out of banana, processed with with combined with syrup. They could be produced into souvenir or custom items. Technology in packaging and labeling is very much needed. Here, thing for processing is and this is grown in Guimaras, of course, also in other parts of the world. So similar to cashew, peanut, banana, pineapple, the investment areas the farm, technology, production, technology, and management, as well in the processing and post-harvest activities that are required in these products. The next category of investment opportunities will be in construction, housing, and real estate. This in the construction industry region, we would welcome the coming in of investors to complement the capacity of our local construction companies. So bridges, one of the main program of the administration is to build a lot of infrastructure, real estate development, and housing requirements for our expanding population. Include retirement villages and real estate development. The next area for investment could be in the logistics infrastructure and refer to the development, the upgrading of seaports, airports, trucking facilities, freight forwarding, and warehousing. We need these investments to hasten our development in terms of the movement of goods and the services as we respond to the demands of the global market. Then the next area will be on IT-enabled services. That would, of course, include voice and non-voice, as well as business process management projects. We have the locators here, but we believe the capacity is still very much wanting, as well as we have five universities, tech institutions, which could provide the required manpower for these investments. There are other investment opportunities in other sectors, such as fisheries and aquaculture, high-value crops, tourism infrastructure and services, but for our limited time, we are not able to cover them now. But we still have, I believe we have a question and answer time, and I hope I can answer your questions in these areas. Thank you very much. Good day. 17 minutes. 2 minutes.
Hi, good morning again. That was a very excellent presentation by Engineer Gustavo Cadena. Thank you very much indeed. Very impressive. So I'd just like to check, we should now have our other speaker, Edmund Baranda. I believe the internet dropped, so you didn't hear my introduction of him, so I apologize for that. Edmund is an IP lawyer in the Philippines with over 10 years experience. He is a qualified patent agent, and he has handled the prosecution of both local and intellectual patent applications. He has extensive drafting of patent application. He has a lot of experience in terms of IPR regulation and the law. And obviously, he is a managing partner of Baranda Associates. So we're very interested to hear from Edmund, and we'd like to thank him again. And now I'll hand over to Ed for his presentation on the IPR in the Philippines. Thank you very much.
Good morning, Mitchell. I'm not sure if I can have control over the presentation. Would you mind if you do the controls?
No, not at all. I'll just be in charge of it, and you just let me know when to go to the next slide.
Okay, all right, okay. Could you go to the next slide now, please?
There we go.
Okay, so this is just a 20-minute presentation. Usually, introduction to IP will take hours, but we'll try our best. So just to give you an outline of what I'm going to talk about, first going to talk about why you should protect your intellectual property in the Philippines and how to protect them, and then some takeaway messages as for entities who are interested in doing business in the Philippines. And after that, if we have time, then we'll have some Q&A. Next slide, please. Okay, we protect intellectual property because number one, we want to protect an entity from infringers. Intellectual property is a very important tool in businesses. It's an important asset as well, and you want only your company to be able to exploit and use your intellectual property. So without protecting your intellectual property, other third parties can use them. So that will definitely have an effect on your on the way you do your business. Also, if you're for example, if you have technologies that may be used by other entities, then they could use those technologies without getting permission from you, and therefore that they will be using your technology without your permission. And if there are investors who are interested in your technology and in your products, then one of the things that they want to see, that they want to ensure is that you're able to commercialize your technology without competition from other entities. So they will first need to check if you have protected your intellectual property before they will even look at possibly investing in your company. Next slide, please. Protecting your intellectual property in the Philippines is very similar to how they are protected in other countries. We have adopted in the Philippines the first to file system, meaning you should be the first entity or first person to register the intellectual property rights here in the Philippines. And for most intellectual property, except for copyrights, you need to file an application here in the Philippines to register your intellectual property. And then, of course, after you have registered your intellectual property, then you should be able to effectively also enforce your intellectual property against possible infringers. And we will discuss some strategies on how to do that. Next slide, please. There are 7 kinds of intellectual property rights under our IP code, as shown in that slide. But I think the 3 most important intellectual property rights that are relevant to businesses would be trademarks and service marks, patents, and then trade secrets. So since we have very limited time, we will just be focusing on these 3 intellectual property rights. Next slide, please. Okay, the first that I'm gonna be discussing is trademarks and service marks. So these are your brands. So this could be any visible sign that is capable of distinguishing your goods or services from other enterprises. Take note of the word visible. In the Philippines, it is required that your trademarks or your service marks are visible. But in other countries, they actually allow non-visible signs to be registered as trademarks. So an example of this would be sound marks, for example, or in some jurisdictions, you even have some smell marks. But for the Philippines, we still have to adopt that. We still require that a mark should be visible. So it could be a word, it could be a logo, it could be a figure. Next, how do you acquire ownership over this mark? And you have to register it with the Intellectual Property Office. So you have to file an application for a trademark or service mark registration, and your application will be examined. The IPO, or the Intellectual Property Office, will check if there are any similar marks. If there are none, then your application will be allowed, and then you will be granted the registration. And this registration is good for 10 years, but the good thing is it's renewable, so it can actually be perpetual. So as long as you continuously renew your trademark registration, then you have ownership over that mark for as long as you want. Next slide, please. So what are the advantages once you have registered your mark? Very important. You now have the exclusive right to prevent everyone, all third parties, from using your mark. So a mark that's identical to your mark, for example, if you're the owner of Coke, so you can prevent other people from using Coke, but you can also prevent other people from using marks that are similar to your trademark. So it could be like a small variation of your trademark. Let's say someone would just add a few letters to your mark, but still will sound and look like your mark. Then you can also prevent these such parties from using a similar mark or similar sign. Even the containers that you use for your products, for example, you can also have that registered, and you can prevent other people from using containers that are also identical or similar. And the reason why I cited Coke is because it's easy to visualize. I'm sure you know that once I show you a bottle of Coke, you already know that that's Coke. So that's an example of a container that is registered as a trademark. So once you've registered a mark like that, then you can also prevent other people from using containers that are similar. The reason why you can prevent other people from using these identical similar marks is because it will result in confusion. So the public will be confused as to who actually from which company that this product came from. So if two products coming from two different countries, the two different entities would be using the same mark, then the public will be confused as to the origin of these goods. So that's what we're trying to prevent, because we only want a particular trademark to be used by one entity, so that people who will buy products bearing that mark will know that, okay, this product came from this company, so I am assured that it will contain certain qualities. Next slide, please. So in the Philippines, once you've registered your mark, you are required to prove use of the mark here in the Philippines. I highlight this because we're a little bit unique. I mean, we're one of the few countries left in the world that require proof of use to maintain your registration. And a lot of our clients actually, I mean, a lot of companies forget about this. That's why they learn later on that their trademark registration has been their mark has the registration has expired or are no longer renewed because of failure to prove use. So the dates that are important here is that from within the third year from the date of filing, you need to prove use of the mark, and once you're registered, you count another 5 years, and on the 5th year, you're supposed to submit proof of use. what if there's no use of the mark? And this happens a lot in the field of pharmaceuticals, because by the time they from the time they file the trademark application to the deadline for the proof of use, it's possible that they have not yet secured the necessary license to sell the medicine. So you can file, you can explain to the intellectual property office that you're still prevented from using the mark. So that's called the declaration of non-use. But what we observe from our clients is that it doesn't matter if they still not, if they cannot use the mark, they would still file these trademark applications as for defensive purposes. Defensive in the sense that you already, even if you're not ready to produce products bearing that mark in the market, then you can already signal to your competitors that, hey, these marks, these are mine. So no one else can use this. So what we do is we just refile the application if they're not able to comply with the use requirement. But at least you've already established that you own this mark, and you can show that you've been filing trademark applications for that mark for the past couple of years. Another thing that we want to achieve once you've registered your mark is that make it so popular that it's now acknowledged as a well-known mark. I mean, there are a lot of examples of well-known marks, and I've already cited an example like Coke, Pepsi. I mean, these are internationally well-known marks. The advantage, that if you're recognized as an internationally well-known mark, is that you can oppose marks that are not registered in the Philippines, and even if these marks are for goods that are not similar to your goods. For example, again, going back to my example of Coke. Coke, as you all know, is a beverage, but since it's so well known, I cannot file an application for the mark Coke for, let's say, for cars. I mean, cars, beverages, very different, not very similar goods, but since Coke is internationally well known, then you can successfully oppose a trademark application for Coke for use in cars or automobiles. Another way to further protect your mark, what you should do is you should monitor third-party filings for marks that are confusingly similar to your trademark. So, because you want to make sure that your mark is unique in the registry, no one else will register a mark that's similar to your mark. So once you learn that a third party filed a trademark application for a mark that's similar to your mark, what you can do is you can file an opposition against that application. Next slide, please. The reason why I included this slide is because in the Visayas, there's a very good example of a collective mark. A collective mark is a sign that can be used to distinguish the origin or any other common characteristic, including the quality of the goods, of different enterprises. So it's a collective mark because there's just not one entity that can exclusively use it, but a collection of organizations. We don't have a separate registry in the Philippines for collective marks at the moment, but we have allowed the registration of collective marks. I think this will be more easy to understand in the next slide. Next slide, please. So this is an example of a collective mark, the Guimaras mango. Guimaras is an island in the Visayas near the island of Panay. And they're known for the best and the sweetest mangoes in the entire world. And they're really, really good. I mean, Philippine mangoes are quite famous, but Guimaras mangoes are on another level. They're really, really sweet. So what the entities who are the farmers who grow the Guimaras mangoes in the island, because there are several farms, several companies that grow the Guimaras mangoes. What they did was they registered this collective mark, and that's what you see on your slide. So that letter G with the mango, and it says Guimaras mangoes. So they register this as a collective mark, meaning that any mangoes that they produce from this island, they can use this brand. So it's actually a sticker that they put on on each mango, just to inform the public that this is really high quality, really sweet mangoes. So that's one option for trademark owners. Next slide, please. Okay, so we're done with marks, with brands. What if your company is involved in producing new technologies? So to protect that, so that's also an intellectual property. To protect that, what you do is to obtain a patent for that technology that you came up with. So patents, you have a long term for that. Long protection is 20 years from the filing of the patent application, to exclude others from using your invention or your technology. So what's an invention? It's defined as any technical solution in any field of human activity, which is, and these are the 3 requirements for patentability. It should be new or novel. So that means that it has not been disclosed anywhere in the world. Second requirement is that it should involve an inventive step. That means that it shouldn't be obvious to a person skilled in the art. To put it simply, something that's not that's tricky, something that an ordinary a person skilled in the art would be able to come up with. So there should be some breakthroughs there. So it's not just like it shouldn't be a very, very simple improvement, for example. And the third requirement is that, of course, it should be industry applicable, meaning it should be useful, or it could be used in any industry. So it has some practical purpose. Next slide, please. Sorry. Could you please go back? To the okay. So examples of patents for patentable inventions to be, for medicine, for example. So you were able to extract a chemical substance that has, for example, has some antibacterial or anti-cancer properties. So that's new because it hasn't been disclosed in the past. So it's a new chemical compound that you extracted from this plant, for example. It was an inventive step because nobody knew that this chemical compound that extracted from this particular plant has some antibacterial properties. Useful because, of course, it's medicine. It can be used to treat diseases. Also take note that you can patent not just products, but you can also patent processes. So, for example, the process of producing beer, for example. Let's say you came up with a new process of producing beer which is more efficient. Let's say with less ingredients, but you are able to produce more beer. So that can also be patented. So both products and processes can be patented as long as you comply with these requirements listed, the 3 requirements. Next slide, please. What if your invention is not, it's not tricky, it's not really fun, as far as technical solutions are concerned, they're not really fantastic. It's just very simple, low-level technology. But it's still new. It still has some practical purpose. You can still protect that. In the Philippines, you could instead opt for a utility model application. So it's so because it's not required for a utility model application, you don't need to show inventive step. So this could be some companies actually opt for this because if they know that their technology will be obsolete in the next few years, and they just want a quick protection, then this is a viable alternative. Quick because unlike patent applications, which will take about 5 years for you to obtain the patent, utility models, there is no substantive examination. So actually, even under a year's time or at most 2 years' time, you can already your application will already be granted. So you have a utility model registration which you can already enforce. again, you do this when you want quick protection and you want to enforce your IP rights against competitors. The downside here is instead of 20 years, you only get 7 years. So it's a relatively shorter term of protection. But again, the idea behind this is because you know that it's going to be obsolete anyway, so you don't need a long protection, long period of protection. Next slide, please. Another kind of patent that's in quotation marks, because we don't call them patents anymore. Before we used to call them patents, but this time we just call them by their names. So industrial registration, industrial design registration. Sorry, the word design is missing there. So this could be any new, original, or ornamental design of an object. So examples could be, say, designs for furniture, designs for like the cell phones, not the technology behind it, but how the cell phone looks, designs for chairs. So these are called industrial designs, and you can have them protected as well. In the Philippines, there are a lot of industrial design registrations because there are a lot of handicrafts being produced here in the Philippines. So like I said, it could be furniture, could be chairs, it could be some other decorative product. So those designs may be registered, and the term of protection is a little bit, it's only 5 years, but the nice thing about this is renewable twice. So the maximum protection would be 15 years. So if you're the type of a business entity that's involved in creating designs, then this, I think, is important for you and something that you should consider when you do your business here in the Philippines. Next slide, please. Okay, some companies, instead of disclosing their technologies, they want to keep it to themselves, and that can also be protected under what we call trade secrets. A good example that I always give for this kind of intellectual properties, the formula for Coke. They never patented it. The reason why it's a trade, it remains a secret because and when you file a patent application, sorry, I didn't mention this earlier. When you file a patent application, in exchange for the 20 years of monopoly for exclusive use of the technology, you are required by the government to disclose your invention. So what you submit actually to the intellectual property office, that will be published. So all the technical description, all the details about how, for example, you manufacture a particular product will be disclosed to the public. And the reason is because we want to expand the knowledge base. We want other scientists, other engineers to build on it. But some tech companies decide, as a matter of strategy, they don't want to disclose their new technologies or the new processes. So they don't patent it. But even if they don't patent it, it will still be protected under trade secrets. It's just that there are 3 requirements. Number 1, of course, it should be secret. Second is that it has commercial value because it's secret. And then number 3, you have to show that you took reasonable steps to keep it secret. For example, any employee that gets hold of information about this trade secret, for example, this new process or this new product, you require them, for example, to sign non-disclosure agreements. So that's an indication that you are taking steps to make sure that the trade secret remains a secret. Okay. The downside here, of course, is trade secret. Once it's disclosed to the public, that's it. That's the end of it. You can only, of course, you can go for damages against that person who disclosed it to the public. But then third parties, that means that the rest of the world, once they get hold of these documents disclosing your trade secret, then they can now manufacture or produce that product, and you have no recourse. Next slide, please. So how do you enforce your rights in the Philippines? We have enough, I think, our laws are sufficient for in enforcing your intellectual property rights. You have a lot of remedies, and as a practitioner, we usually enforce the intellectual property rights of our clients against those who sell counterfeit products. Next slide, please. So once you learn that some business or some entity is using your trademark without your permission, then you can file a trademark infringement case against them. Of course, for a trademark infringement action to prosper, you must register your trademark. What if you didn't register your trademark, but you've been using that mark in your business for a long period of time? You still have a cause of action. You can still file what we call an unfair competition action against that company, because that company is making it appear that their goods that their goods are your goods. So they're confusing the public as to the source of the goods. So two elements that we've shown here, there must be a confusing similarity in the appearance of the goods, and then of course there's the intent to deceive the public. Because they're passing off their goods as your goods. Your name, the name that you use in your business, even if you don't register them, that's also protected. That's called trade names. That's your trade name. So you can, even if you don't register as a trademark, but you use it in your business. So for example, it's the name of your company. It's the name that you put up in your, if you have a shop or a store, and you use a particular name as the name of your shop, then that's your trade name. You can also, that's already protected even without registration. Next slide, please. How about patents? Once you have a patent, it's a very powerful right, because you can prevent other people from making, using, selling, and even importing your patented product. This is unique to patent rights, because even patent in the importation of the patented product is your exclusive right. So how do you go about enforcing your patent rights? Similar to trademark rights, you can file an action for infringement, and of course you ask for damages. I forgot to mention that for trademark and unfair competition actions, you can also file criminal cases against the infringers. But for patent rights, at the first instance, you cannot file a criminal action because it's not considered a crime. But a repetition of the infringement, then that's a crime. That will make the infringer criminally liable already. You have options to file with the courts, or you could also file an unreserved action with the Intellectual Property Office, which we usually recommend because judges normally do not have the technical know-how to understand your invention. So we usually opt for the Bureau of Legal Affairs of the Intellectual Property Office, because the examiners are very well versed in IP rights, and there's a greater chance that they will understand your invention and why your patent rights were violated. Can be filed by the patent owner, and even if that patent owner is not licensed to do business in the Philippines, as long as that entity is the registered patent owner, then you can file this infringement action here in the Philippines. Next slide, please. Trade secrets. Our penal laws on trade secret violations are outdated. But still, you can have a recourse for trade secret infringement. You can ask for damages as well against that person who divulged your trade secrets. But it's quite difficult to enforce. It's because at the end of the day, your trade secret is out. I mean, you can only seek damages, but bottom line is that once it's disclosed to the public, then that's it, and everyone can use your trade secret. So again, going back to Coke formula, now once the formula for Coke is disclosed, Coke has a cause of action against the person who disclosed the trade secret, but the rest of us who got hold of the recipe for Coke can now make their own Cokes, and Coke cannot go after us. So the lesson to be learned is that if you have a trade secret and you don't want to patent it, you want to keep it on your own, and this is this usually used in the food industry, you know, like your secret recipes. These are trade secrets. You operate a restaurant, for example, and you develop a secret recipe for your muffins or for your you know, for your pastries. If you're in that kind of business, we do encourage you to take the necessary steps to protect your trade secrets, so you don't have to go to court. So you better make sure that your non-disclosure agreements are watertight. You educate your employees about disclosing secrets or the trade secrets, or even again, take steps to make sure that only those who are people who you trust, people who employees who occupy, you know, senior positions, make sure that they're the only ones who get hold of the trade secrets. But your low-level employees or ordinary employees, don't disclose to them your trade secrets, because again, just one disclosure by these employees and that's the end of your trade secret. Next slide, please. Okay, this is actually my last slide. Again, very limited time, so I just focused on those 3 intellectual property rights. But what are the takeaway messages? The Philippines has an effective IP system in place, and I think even if you talk to our Intellectual Property Office Director General, she would say that we have probably supposedly the best intellectual property system in place in the ASEAN, because, you know, all sorts of IP rights are protected, and you have remedies for those who infringe your IP rights. But again, if you want to enforce your IP rights here, you have to register your marks in the Philippines. You have to patent your inventions in the Philippines, because there's no such thing as international patents, for example, or international registration without involving the Philippines. So you have to register your IP here in the Philippines. And again, I like to emphasize, for trademark registrations, we are a little bit unique. You need to prove use of your mark, otherwise your trademark registration will be cancelled. You must monitor the Philippine registry for any marks that are being applied, similar marks that are being applied for registration, and you must file oppositions against these applicants, so that your mark will not be diluted, so that no one else can appropriate your mark or a mark similar to your mark. Next slide, please. Okay, that's it. I'd be happy to answer your questions later.
Hi all. I'll be doing the question and answer portion. So first question comes out from Mary Stromse. He writes, my business partner in Manila has promised to take care of all of my PM registration in the Philippines. I'm a bit hesitant. Is there something I need to consider? I believe that goes out to you, Edmund.
Leave anything different. Just check. Take this. No. It's just all no, it's all just this stuff.
Hello. Okay. Good question. Actually, it has happened already here that the Philippine company or the Philippine individual that they deal with registered the trademarks in their own name. So it has happened. So I do realize that you'd be hesitant to trust your people here to protect your IP, but there's a way to go around it to ensure that that doesn't happen. Number one, make sure that when they file the trademark application, make sure that it's under your name. And I think it's best to ask a professional, a trademark like a law firm or an IP firm to do that for you. Because if you rely on that individual in the Philippines to do the filing for you, then there's no way for you to actually check whether the trademarks were filed in your name instead of in the name of that employee. So better to use professionals for that, because they will be clearing the applications with you before they file it with the Intellectual Property Office. And then also, as far as maintaining the trademark registration, you'll always go through these trademark agents, whom you can trust, so that just to ensure that the marks are really registered under your name. Also to make sure that they maintain the registration. Also, one thing that I will also say is that if you're going to license your mark to entities here in the Philippines, again, just make sure that your trademark licensing agreement is also watertight. You have provisions there about how the mark should be used, for how long the mark can be used, and you could also include the penalty clauses for violation of the trademark licensing agreement. I mean, if you have more specific queries, I will be happy to address them later.
Okay, thanks so much for that answer, Edmund. Next question actually comes out for Engineer Cadena. What are the biggest issues that entrepreneurs usually face in Visayas?
Just that the entrepreneurs facing the Visayas. So one of the issue for now is actually the issue of ownership of land or property. So since I presented the investment opportunity in construction, the issue as to ownership of land or real estate property, there are certain limitations with regards to foreign ownership. And at present, of course, the corporate law applies wherein it should be no more than 40% ownership by foreign investors of land and real property. But I think the issue now is that the present government is trying to do some reforms, undertake some reforms to relax these limitations on ownership of land and property.
Thank you. We actually got another question from Michael Lecomte regarding that. Anything to add? Is there any positive development under the new administration in terms of ease of doing business? Anything to add to that?
Come again? Can you repeat the question, please, Ms. Clara?
Is there any positive development under the new administration in terms of ease of doing business, other than what you've already mentioned?
Yeah, I believe a lot is being lined up for easing the requirements for doing business in the Philippines. That's even part of the main concern in the proposed amendments of the Philippine Constitution. And I see and I believe that the present administration is inclined towards really easing these requirements to make the country and our region competitive in the ASEAN and even, of course, internationally.
Great. Thank you, Engineer. We have a question here for Edmund. Is criminal action for PVP infringement possible?
Yes. For trademark infringement and copyright infringement, you can file criminal action against the infringers. And it's a good deterrent. Once you file a criminal action against these infringers, most of them would try to settle because obviously they don't want to go to jail. But as a practitioner, we actually discourage criminal litigation because it just takes so long, and it sometimes takes 7 years or 10 years. So what we do is through a demand letter, you can send a demand letter, threaten them with criminal action, and then actively follow up on that demand letter and try to negotiate for a quick settlement. But it is an option, but something that we would reserve for really the big infringers, those who still would not comply despite the demand letter that was sent to them.
Sorry to really briefly cut in here, but Edmund, I think the question was specifically targeted to plant variety. Is it?
Oh, sorry, I forgot that part. Plant variety protection. If there's a criminal is that the question?
PPP was mentioned, so that should be a plan for ID protection.
Yes, there's a criminal liability as well for infringement of Plant Variety Protection Act. But it's just want to make sure that to emphasize that plant variety protection is not considered a patent. It's a sui generis, so we have a separate law for that. It does grant patent-like rights, but strictly speaking, it's not called a patent. It's not even under our intellectual property code. But yes, there are civil and criminal remedies for a violation of plant variety protection registrations.
Another question from Casper on that. Is there any recent jurisprudence on PVP infringement?
None, because it's a relatively new law. I haven't heard of, or it hasn't reached the Supreme Court as far as I know. I'm not even sure if there were cases already filed with the courts. We do monitor the courts for such kind of cases because it's rather again, it's a new law, and we haven't heard of criminal or civil action based on plant variety protection, as far as I know.
Okay, thank you.
Sorry, just that it's possible, of course, that there are some issues already raised, but probably they settled it out of court because we haven't heard of any PVP case that's decided by courts.
Okay, thank you, Edmund. We have another question for you from Michael.
Okay.
How can companies protect unregistered rights during missions or trade fairs, especially if registration is too late?
Okay, so you mean trade fairs, and then you're dealing, you're disclosing some technologies? Is that the context of the question? Or it could be either.
Probably.
Yeah, it's
okay, so
let's assume it is.
Okay, okay. So trade fairs, you'll probably be bringing in some goods, some products, and you'll be of course displaying on a trade fair and then show to the public. If there are certain technologies there, we would discourage you from attending the trade fair if you don't have patent protection, because if you publicly display your product which contains some technology, then that's already novelty destroying, because novelty is a requirement. So once you disclose your technology to the public through a trade fair, that means that you're already showing to the public, then you can no longer patent that. So before joining these fairs, we suggest that you patent your technology first in the Philippines. As far as marks are concerned, yes, it should also be nice. I mean, it would also be great if you already register before you join these trade fairs. But if you haven't, it's not as fatal as a patent application, because you can always register your mark years and years after you use it, because there's no expiration for that. It's just that in terms of enforcement, trademark infringement is much easier than unfair competition, because unfair competition, even if you didn't register your mark and someone uses it, you can still go after that person. It's just that you have your cause of action would be unfair competition and not trademark infringement, and unfair competition is a little bit more difficult to prove.
Okay, thank you, Edmund. We have a question here for Engineer Cadena. Are there any PEZA?
Okay. Okay. I'm ready.
Zones currently in the Western Visayas region? Yep. Oh, sorry, did you not hear my question?
Yeah, I didn't hear a question.
Oh, sorry. The question is, are there any PEZA eco-zones currently established in Western Visayas?
Yeah, there are, but they are not yet operational. So I think one possibility for your group there in the UK is to take a look at the approved PESA zones, and probably they could take it for maybe the one to develop that together with our locals here in the region. There are no, I actually I cannot give you the specific list, but we have the list with the PESA or the Philippine Ecozones Authority, and it can be seen, it can be obtained in the DTI website.
Great, thank you, sir. I guess we can take one last question. This is for Edmund. You mentioned monitoring third-party filed trademarks. How do I do this, or where?
So, sorry, can you repeat the question?
You mentioned monitoring third-party filed trademarks.
I see.
How do I do this?
Okay. Every month or every 2 weeks, the intellectual property office would publish trademark applications online. So it may be too cumbersome for non-practitioners, but you can. I mean, if you don't want to hire a trademark agent or an IP firm to do this for you, you can do this on your own. You just have to log on to the IPO website and then just click on the link on the trademark applications that were published. So that's what we do. It's one of the services that we provide to our clients, because we handle the portfolio of our clients, so we know all their marks. So what we do is every time that the IPO publishes these trademarks, then we go through them one by one and see if there's any mark there that's similar to our client's mark, and then we report it to the client. And then you have 30 days from the publication to file an opposition, but this is extendable to a maximum of 120 days. So lots of time, but that's how you do it. Just go online, go to the website, and go through the marks that were published for opposition.
Well, great. Thank you so much both for all of your excellent inputs. I guess you can wrap this up now. But before we go, I have a few announcements. So actually, the main reason we held this webinar is really to, in line with our upcoming mission to Iloilo that the British Chamber is organizing. And we're doing this in partnership with the Great Embassy. And this is going to happen on 8th to 9th of March. And the first day, we're going to have a forum. Next slide, please. And we have this lineup of speakers so far, really to talk about innovative practices in the region. Hopefully, this will bring more interest to not just Visayas, but to the Philippines in general. And if you'd like to find out more and register, you may go to the link on the slide, tinyurl.com/Iloilo mission. And thank you so much. Yeah, you can wrap up.